Good day. Welcome. This is the Employment Law Show. Good to have you along over the next half hour. You will guaranteed one thing. You will learn lots about your employment rights as they affect you, your friends, family, co-workers, and everybody around you. Guaranteed. To reach out to Lior Samfiru, right beside me, co-founding partner of Samfiru, Tumarkin, LLP, the most positively reviewed law firm in this country. Phone number, 1-855-821-5900, help@employmentlawyer.ca for a very simple email. And the website we're going to refer to in probably a minute or two, pocketemploymentlawyer.ca. It is chock full of employment law information, and wrapped up into that is a super handy tool which has been around for many years called severancepaycalculator.com. Lior built it, and now over 2 million people have used it. 2 million people have used Severance Pay Calculator at pocketemploymentlawyer.ca. So we'll get into that in just a bit. On the show today, Lior, what you need to know about changes made to your job, that's in a little bit. But we always start with the case of the day, or a week that was, pal. What do you got for us?
Hey, John, great to be here. And I continue always to be busy. And I know I've been saying this for years, and it continues to be true. The bigger our team gets, the busier it seems that we continue to be. And obviously, over the past couple of years, the pandemic has been a huge issue when it comes to workplace rights. A lot of people either losing their job, being put on temporary layoffs, or having their job changed, or people, especially over the last number of months with mandatory vaccines, either being put on leave or losing their job because of vaccine. I've been dealing with those issues. I represent hundreds of people across the country in those situations. So I want to always be able to come back here on this show and tell you what you need to know to make sure you understand your rights, because you have excellent rights. I see some people posting online sometimes saying, wow, we don't have good employment law rights. You only think that because you don't actually necessarily know what those rights are. So by watching this show, by hearing us on radio, by seeing us online, whatever it is that you do, you'll learn about your rights. You'll learn what to do if your employer does something to you, if you're facing a dilemma or an ultimatum, or you lose your job, or the job that you have is being threatened. Whatever that issue is, there are things that you can do. There are legal solutions and options that the law provides for you. And on this show, we talk about those every week. But now that we know that, and we'll give you, by the way, the contact information to reach out to me privately if you want. But let me talk about a situation that came across my desk, and kind of changing gear a bit from the pandemic types of issues that I've talked about. So I've spoken in the show before, John, about workplace harassment, and I've said that if you're going to pursue something as a result of workplace harassment, we need to be able to prove that harassment, because the person that's harassing you, that's mistreating you, is not going to admit it. They're not going to hang their head in shame and say, yes, I did it. They're going to deny it. They're going to say, no, it never happened. I don't know what you're talking about. But if we can prove harassment, man, we have all sorts of options and all sorts of things that we can do to deal with the issue, whether it's to fix it or to get you out of there. So this person that I spoke to, this lady that called me beginning of the week, took that advice to heart. And she knew that her boss oftentimes is belligerent and puts her down, and is even threatening to her. So went to a meeting with her boss, and in her coat pocket, she had a little recorder. And she recorded about an hour-long conversation that she had with the boss. And I listened to this recording, and sure enough, in this recording, there was an entire array of inappropriate language, and yelling and threatening and putting her down. Absolute harassment, absolute bullying, clearly creating a poison work environment. Now that we have this proof, she has all sorts of options. She can go with it to HR if she wants. She can pursue a constructive dismissal and leave with severance. And I'm going to help her do that and make sure that she's compensated and that she doesn't have to deal with this boss anymore. So same with you at home. I'm not necessarily suggesting you have to record. That's certainly an option. But if you're facing harassment, you do need to be able to prove it somehow. So is there emails? Can you create that email track? Do you have a record of notes that you took of what happened? Some way to prove it. Recording works really well. You are allowed to record a conversation that you are part of. You can't record a conversation that you're not part of. But as long as you're part of a conversation, you are allowed to record even if the other person doesn't know. And that could be absolutely useful in proving harassment.
You know, you mentioned emails. If you don't have a recording with you, again, between you and the person involved, that's fine. But say you send some emails to whomever you're supposed to send them to documenting this harassment, but it's radio silence. You don't get any response. You're starting to panic a little bit, right? What happens then?
So an example may be you send an email to the boss saying, today during the meeting you call me all kinds of names. I don't appreciate that. You don't need a response. Their silence is the same as their acceptance. So what matters is you sending that email. Even if they don't respond, that's perfectly fine. You can take that as acceptance. That's going to help you prove what happened. So send those emails, absolutely. Create that record. It's going to be important if we pursue the matter.
It's interesting, too. What does one do if they're being harassed at work? And say there's, a chain of command you have to go up to report the harassment. It's not a small shop. It's a pretty robust workplace with HR. And, you complain to somebody who's supposed to, they say, come on, not a big deal. Boys will be boys. Slap on the back, you'll be fine. I mean, what do you do at that point?
Yeah, and I laugh because I've seen that happen. Certainly when I started practicing some 20 years ago, I saw that often. Oh, come on. He didn't mean it. That's just the way Joe is. Well, no, those things are to be taken seriously. And if you've spoken to your boss, to HR, to someone, and they're not taking it seriously, if they're not doing what they're supposed to, which is to investigate and to eliminate the problem, then that itself could be a constructive dismissal. They're breaching their legal obligations. It's not just a moral or ethical obligation to deal with workplace harassment. It's a legal obligation. So if you can show that you've spoken with someone in the workplace, you've spoken to the right person for you, and they did nothing about it, you better believe that that is a constructive dismissal, and you can absolutely then pursue your termination entitlements.
And finally, at the situation where the right person you're supposed to report to is the one doing the harassing, now what do you do?
Yeah, then you can't deal with it internally. Who am I going to complain to? Because there's no one. It's a small shop. The owner is mistreating me. Well, that's when we gather the proof, as I said, recording, emails, journal, what have you. And then I deal with it. I get you out of there. I get you compensated so that you don't continue working in this bad environment that ultimately may well start impacting your health. You really, really don't want that.
So you want to keep that phone number at all times and reach out to Lior and his team, 1-855-821-5900. Email address if you prefer, or in addition to, is help@employmentlawyer.ca. And simply employmentlawyer.ca, that'll jettison you to the firm website. There's a media tab there. And the benefit of that is you can search and find a radio show, which we've been doing for about a decade, I think, this year. Comes up on 10 years, our radio shows across the country. You can tune into those and have the opportunity to pick up a phone and call in and ask your questions as well. I want to play back some of those calls always on this show here, Lior. In fact, we'll do the first one from one of our radio shows right here, right now.
I was let go, just a small company I had been working at for over 10 years. I'm 55 years old. I'm just wondering what I would be entitled to or what I can expect to be entitled to.
What type of level of job was it? What was
It was a technical job. It was to essentially increase revenue for the company in an engineering capacity.
Huh.
So this is a common question that we get, or a common misconception that I see, that, well, small company, do they have to pay severance at all? Maybe they don't have to pay. It's only a small little shop. Big misconception. So let's clarify that for once and for all. Doesn't matter the size of the company, okay? Big, small, 1,000 employees or one employee. If you lose your job, that company has to pay you severance. The size of the company is not going to change at all the amount of severance you are owed. Huge misconception, huge misunderstanding of how the law actually works. So if you work for a company for with one employee, or even a short service employee, it doesn't matter. You get paid severance. Now, for this person that called our radio show, let me tell you, in fact, let me show you how much severance he is owed. Let's use our severance calculator. You can find it at pocketemploymentlawyer.ca. Again, it's pocketemploymentlawyer.ca. There's several options there, including our severance calculator, which, by the way, is free and anonymous, easy to use. Let's see how much severance we get for this person with the small employer that's worried about losing his job. So we know that he's in a technical role, been there for 10 years, 55 years of age. You see at the bottom of the screen, even though small company, he's owed 12 to 14 months of severance, okay? 12 to 14 months of severance. And by the way, John, that answer would have been the same whether he worked for that company or for a huge, massive company with thousands of people all over the world. He would still be owed the same 12 to 14 months of severance. So for you as well, if you lost your job, are worried about losing your job, or just want to be prepared in case it happens, go to pocketemploymentlawyer.ca, grab the smartphone, your tablet, whatever, use our severance calculator there. You'll find out in seconds how much you are owed, and then you can be armed with that knowledge in case you ever need it.
You know, it's interesting, too, because people will hear that phone call and figure, oh, that's obvious. He's in a technical position. He gets severance. But you also have a lot of misconceptions when it comes to that boundary. People think, hey, I'm in a sales job. I don't get severance. Or I'm part-time. Part-timers don't get severance. Construction workers don't get severance. There's all kinds of those out there, isn't there?
Construction people believe don't get severance. That's wrong. Part-time employees, people believe don't get severance. That's wrong. People, quote-unquote, on contract believe they don't get severance. Wrong, wrong, wrong. Here's the best way to look at it. First of all these people get severance. If you have a job or had a job, if you lost that job, you are owed severance. Again, assuming you're not part of a union. If you had a job and lost it, you are owed severance, and you can go right now to use our severance calculator at pocketemploymentlawyer.ca.
Another way to ask questions anytime. We'll give you something else. Terminationquestions.com. It's a beauty. You can go there. It's free and anonymous. Lior and his team answer these all the time. We'll get to one right now. Trina, this time around, Lior says, I was laid off over a year ago. I was told I would get a small payment if I signed my walking papers before leaving the termination meeting. I decided not to, and so they paid me nothing. I tried to contact them afterwards to discuss this further, but they ignored me. Do I still have time to do something about it? Just over a year ago.
Absolutely, yes. Whether it was a temporary layoff or a permanent layoff, she is owed severance, and those rights don't expire for 2 years. She's had 1 year, so she still has time to deal with that. Remember, you don't have to, in fact, you shouldn't ever sign that severance letter, whether it's on the spot or a week later, whatever the deadline is. You don't need to sign it by that deadline. Your legal rights don't expire on that deadline. You have, as I said, 2 years to pursue your rights. But if you sign it because you didn't know any better, because you felt the pressure, you signed it anyway. Unfortunately, you can't do anything about it. At that point, you're stuck, you're done. There's nothing more that can be done. Please don't let that happen. In this situation, she never signed, so she's owed what she's owed, and depending on her age, her position, and the length of her employment, she could be owed as much as 2 years' pay. But the key here, what I want everyone to take away from this conversation, is you cannot ever sign that severance letter without getting some advice, without going to pocketemploymentlawyer.ca. And I've said this before, I'll say it again. If you don't like me, you want to speak to another employment lawyer, that's fine, then do that. But what you cannot do is just sign that letter without understanding what you could be giving up.
Coming up here after a short break, what to know if changes are made to your job. We will get to that topic of the day. First, phone calls. We get into a break. 1-855-821-5900 and help at employmentlawyer.ca. This is the Employment Law Show, and there's more on the way. Don't go anywhere. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks for sticking around with us. Employment Law Show. John Scholes here. Beside me, Lior Samfiru, the co-founding partner of Samfiru Tumarkin LLP. Reaching out anytime, 1-855-821-5900 and help at employmentlawyer.ca. Want to get into our topic of the day, Lior, that is what to know when changes are made to your job. And the first one's kind of the big overarching question. Can your employer make changes to your job?
So, John, this is going to be a discussion of this concept of constructive dismissal. And constructive dismissal happens when an employer makes a significant change to the terms of employment, and you, the employee, choose to treat that as a termination. You don't accept it. And when you don't accept it, you treat it as a termination, you leave, but the law still looks at it as if the company let you go. Therefore, you get severance. So that's what a constructive dismissal is. A significant change you don't accept that results in a termination, and now you're owed severance. So what flows, of course, or the first starting point is what kind of changes are they allowed to make. So an employer does have a right to make some changes to terms of employment. It's not the situation where they can't touch anything. So they're allowed to make some minor changes to your pay, up to, let's say, 10%. They can make minor changes to your hours. They can change your job responsibilities a bit. So these small changes are allowed. Now, obviously, sometimes it's difficult to know, is this change big enough or is it not big enough? You can always call me so we can discuss it. I mentioned pocketemploymentlawyer.ca. We have our constructive dismissal tool there that allows you to assess whether your situation results in a constructive dismissal. But generally, yes, your employer can make some minor changes to the terms of employment, but minor only.
Yeah, it's interesting. We talk about this all the time, these minor changes, and I guess it's really bespoke, right? It depends on the individual. I mean, you and I often talk about the fact if we worked for the same employer and, you drove to work every day, it took you 10 minutes to get to work, I took 3 buses. Well, if they move 6, 7 kilometers or 20 kilometers away, that's really going to upset my day. You might be like, no big deal, brush it off, right?
Yeah.
But same thing.
Same change, but affects people differently. So the question always is, how does it affect you? If it's really nothing that's going to affect you too much, it's probably not a constructive dismissal. If it's going to impact you, even though it may not impact someone else as much, we may well be in constructive dismissal territory. Again, that's why it's important to understand that every situation is different. You can't Google the answer. That's why we need to discuss it if you ever find yourself in that scenario.
So if somebody's in the situation where a big change has taken place and they don't like it, they're not happy about it, but they really like their colleagues, they love working there, what happens if they continue working following that big change? What goes down then?
So when it comes to big changes, we're talking about things such as significant salary reductions or, demotions. If they change your hours or from, a day shift to night shift, or the days of work, they have to have you work on the weekends when you weren't working before. All of those are significant changes and can result in a constructive dismissal. Well, what happens if you continue working? You want to be that kind of good soldier. You want to continue working despite this change. The problem with that is by accepting the change and continuing to work, you've given the company the right to do it again. So right now you've accepted this pay cut because you want to be the good soldier. You're happy to be employed. I understand that, and that makes a lot of sense. But I want you to remember that by accepting this 15% pay cut, you've given the company the right to do it again and again and again. And the next time they do it, and the time after that, and the time after that, there's nothing you're going to be able to do because you let it happen that first time. That's why it's important at least to consider the option of constructive dismissal if your employment terms are being changed. You only have one chance at it, and if you miss that chance, you may not be able to do it again. So just continuing to work may not be an option that makes sense.
Can you, in that regard, can you bring in a bit of a stopgap, meaning if it's maybe a slight change to your pay or a slight change to your hours, and you're thinking, maybe it won't be so bad. In fact, maybe it might be a nice change if I get used to it. Can you try it, take it out for a spin, but still go back if you don't like it, if it affects you negatively? Can you do that?
So if your job has changed, something has changed, and you don't like it, but you're not necessarily ready to say constructive dismissal, you want to try it out for a second, you can, but I want you to do 2 things. Number 1 is you have to tell your employer that that's what you're doing. In writing, email works great. Say, employer, I'm not happy and I'm very concerned about this change, but I'm going to try it for a little while and see, and then I'll let you know how I feel about it. So that's number 1. The other thing is you can only do that for a short period of time, a few weeks, say 2-3 weeks. After that, if you say I'll try it for 6 months, the problem with that is by then you're going to be deemed to have accepted the change. So yeah, you can try it out for a short period of time, but make sure you tell your employer in writing that that's what you're doing.
Yeah, 10 years in, hey, you know what, I don't like it, I'm going back. It doesn't work that way. It's got to be a little shorter than that. Can you get compensation if changes are made?
So that's what a constructive dismissal is. If you are facing a significant change and you decided, no, that's not on, I'm not accepting this, no way am I gonna work weekends like they're telling me I have to, then you can leave, and yes, you can be owed compensation. The amount of compensation you're owed is the same amount of severance as if the company decided to let you go. It's the same amount, meaning it can be as much as 24 months pay if you work there long enough, or if you're older, or if you're in a senior role. So to find out how much severance, you know what to do. We've talked about that. Go to pocketemploymentlawyer.ca and calculate your severance there with our severance calculator. It works just the same whether the company lets you go directly or whether, like this, it's a constructive dismissal.
So let's talk about in the event that that's going down. Let's talk about steps taken. Do you just say, you know what, I quit first. Okay, now I'm going to work on severance, or you do it the other way around?
So no, well, I don't want anyone to quit, John, before speaking to me. Okay, no one quits. So you may think, oh my God, this is a clear case of constructive dismissal. You know, they've reduced my pay by half. Sure, and it may be, but we still want to do it correctly. We want to quit, quote unquote, in the right way at the right time with the right resignation letter. So you don't quit first and then think of a constructive dismissal. You speak to me first, and if we decide that, yes, you have a case for constructive dismissal, we'll put a plan into place as to when you leave, how you leave, and what you say on your way out. So that's what you do. You don't put the cart before the horse. So no one quits ever because of a constructive dismissal without talking to me first.
As mentioned earlier, employmentlawyer.ca, the firm website, a perfect place to find a radio show across this lovely country of ours where you can tune in. In fact, you can call in and be part of the show anytime you like. We'd like to play them back here and talk about them. I guess this is phone call number 2 from one of our radio shows coming up right now, Lior.
I'm on short-term disability right now. Got some issues with depression, anxiety, and some of that was caused by the employer, the work environment, and some was personal. And my question is, let's say when I'm ready to sort of like come back to work, I don't want to come back to this employer. Is it more difficult to get a settlement to exit the company when you're on disability, or are there strategies to make that happen?
Mm-hmm.
So, number one, it would be very helpful to have something from your doctor, a doctor's note saying that the reason why you're off sick is because of what happened in the workplace, because of the work environment, okay? But even beyond that, as I said earlier, we need to have a way to prove that harassment, that mistreatment, if we're not going to have you go back. Now, if you don't have a way to prove it, if it's your word against someone else's, you may want to consider going back to work and starting to document things. So when you go back to work, one of two things will happen. Either somehow the harassment stops and you can continue working. That would be obviously great. That would be the best case scenario. But if the harassment doesn't stop, now you know you have to start documenting things, emails, letters, recording. And then once you have that documented, especially if you also have a doctor's note saying you're sick because of it, then now we're in business and we can absolutely pursue compensation and severance and get you out of there. So the question I'm always going to ask you if you're talking to me about workplace harassment is, what do we have to prove it? And if we don't have something, let's talk about how we put a plan in place to get that proof, to get that evidence so that we can pursue it and get you compensated.
Want to get to another job here, I think, Lior, very shortly. Or are we going to do that now? We could do that now. No, we'll take a break. Get to that other call and maybe some other things on the other side. I want to give you a phone number before we get cut out for a second, 1-855-821-5900, and an email address anytime, all the time, help@employmentlawyer.ca. We'll continue. It's the Employment Law Show. Stick around. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Employment Law Show, employmentlawyer.ca. As you just heard there in that commercial, is the place you go for all things concerning Lior and the firm, and contact information, and also a list of radio shows across the country where you can tune in. I mentioned phone call number 3 from one of those radio shows. Let's get to that right now, Lior.
My situation is I'm a truck driver. I've worked for this company for 21 years, and now they want to take my truck and about over 250 kilometers to commute there. Gas, I have to start 2 hours earlier in the morning. I can't accept that. I told them that's unacceptable, and they wrote one back saying, basically, too bad. We'll extend it 3 months. You shouldn't have any problem getting another job.
Wow.
Yeah. Well, it's a huge deal, and this aligns so well with what we were talking about before the break, which is constructive dismissal. He's going to be relocated 200 kilometers. Of course, that's a constructive dismissal. It couldn't be more of a constructive dismissal, right? So he can treat that as a termination of his employment and get severance. Now, this company gave him 3 months notice. So essentially they're saying we're going to pay you for 3 months. For 3 months, things are going to stay status quo. Well, those 3 months do count towards his severance. But guys, after 21 years, he's going to be owed a heck of a lot more than 3 months. So rather than me just tell you how much he's owed, I can, but let me show you how much he's owed, and let me show you how you can find that out for yourself. Just go to pocketemploymentlawyer.ca. We have our severance calculator there. Let's take this person's information, let's plug that into the severance calculator, and let's see what comes out. So we know that he's a truck driver, been there for 21 years, 53 years of age. Now we see that he was given 3 months notice. That counts towards his severance. But what he's really owed is 18 months. 18 months less the 3 months that he was given. Another 15 months of severance is what he is owed. So that's how easy it is to use, and you can do that yourself. And remember, he's not necessarily let go. He's choosing not to relocate. But because it's a constructive dismissal, his employer doesn't have a right to relocate him that far away. So because it's a constructive dismissal, he gets the same amount of severance. For him, that's 18 months pay.
TerminationQuestions.com. Let's slide one of these finally into the last couple of minutes of the show. Lior, Nikolai is writing in, says, I was fired for cause months ago due to my COVID-19 vaccination status. Now that my employer has ended their vaccine mandate, do they have to take me back? I'm still looking for a new job, but it's been really difficult to find anything in my field of work.
So in terms of taking him back or not, that is up to his employer. The employer does have the right to decide who they're going to hire, who they're not, who they're bringing back, and who they're not. What's key here is that this situation, being put off on a leave because of a vaccination status, is something that's a termination. It's a constructive dismissal. If you're put on a leave because of your vaccination status, you're owed severance. You can treat that leave as a termination. So, John, he doesn't have to wait and see what his employer does. He can choose now to treat his leave as a termination. He could have done that on day one. Same with you at home. I know there's thousands of people across the country that have either been let go or put on a leave because of their vaccine status. Regardless of any of that, you are owed severance. The losses can't just be put off work without compensation, without severance. You are owed that severance. I know a lot of you haven't been paid that. I'm working with many individuals. If that's your situation, if you're let go on a leave, you're not vaccinated, because of that, your employer doesn't want you there, fine. They can put you off work, but they have to pay you your full severance.
Same goes for temporary layoffs during the vaccine, or at least during the pandemic as well, which, by the way, March 2020, way back when, we're getting close to the time limit of 2 years, if not over, right?
Yes, for those that have been put on a layoff, whether it's back in the beginning of the pandemic or since then, you can treat that layoff, that temporary layoff, as a termination and get severance. Your employer does not have a right to keep you off work without pay.
Want to reach out with any of those matters? Do so right now. 1-855-821-5900. The number, email help@employmentlawyer.ca, and then pocketemploymentlawyer.ca. We'll catch you next time. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.